good.
Good?
Yep.
Okay, I'd like to call to order the Board of Education special meeting Wednesday, October 16th at 7 o'clock. Roll call, please.
Mr. Brady?
Present.
Mrs. Capabianca? Here. Mr. Cavanero?
Here.
Mrs. Holman is here. Mr. Kisco?
Here.
Mr. Marola?
Here.
Mr. Nergy?
Here.
Mr. Rivero?
Here.
Mr. Tebow?
Here.
Mr. Traub?
Here.
Mr. Campolita?
Here.
Mrs. Clacko?
Here.
Acting Mayor Zordi?
Okay. We also have in attendance Rich Mills, Shipman and Goodwin, the board's legal advice. We'd like to go on to the receipt and discussion of the investigation of a BOE member, and I'd like to call up Chuck Stoller, the investigator, please.
Okay.
Yep.
Good evening. Mr. Traub, I just handed to you a copy of my report. It's in caption, Confidential Report to Torrington Board of Education, September 2013 investigation. It's a 6-page report, and what I would intend to do is walk the board members through that. Good evening to each of you. I did meet you in the course of this investigation, and it's good to see you again. And so my plan would be to review this with you, hitting the key points that are in my report, and then be happy to answer any questions that any of the board members have. I have been involved in this since September 19th, when you, Mr. Traub, asked me to conduct an investigation of a complaint involving a board member which occurred at a board committee meeting. And you called me pursuant to a motion that had passed 7-3 by this board at its meeting on September 18. And I quote, and won't read for you what that motion is, but authorize the board chairperson to facilitate this investigation. On September 23, a couple days later, I met with you, Mr. Traub, and also with Joseph Campolita, the Director of Human Resources, to understand the complaint and gather the necessary background and documents. And the complaint was made by 3 senior administrators about the conduct of board member Paul Cavanero at a meeting of the School Improvement Committee on September 11, 2013. I think, as the board members know, my contact throughout this process has been Mr. Traub and Mr. Campolita to help arrange meetings and provide any necessary background information. The process that I followed to investigate this complaint about the conduct was the following. This complaint was filed by 3 administrators, Patricia Fazioli, Susan Limbowski, and Kathy Sosnowski. All 3 of those women are curriculum, instruction, assessment, and technical directors. You all refer to them as CIAT. And they were present at the School Improvement Committee meeting on September 11th. On the day following the meeting, Ms. Limbowski spoke to HR Director Campolita. On the day following that, which would have been September 13, Ms. Fazioli spoke to the superintendent. There is no written complaint. Both of the administrators who spoke orally alleged that Mr. Cavanero's conduct at the meeting was aggressive, harassing, intimidating, unprofessional, and abusive. The 3rd administrator, Ms. Sosnowski, supported the allegations made by the other 2. The superintendent, as I understand it, the superintendent, Mr. Campolita, and you, Mr. Traub, conferred, and after consultation with counsel, began and decided that an investigation should be conducted, and that led to the motion that was passed and is quoted above at your board meeting. I have met with the administrators, the superintendent, and others at the central office, and as a matter of due process, I interviewed each of you as the current board members. At the beginning of each of the interviews, I tried to use the same basic approach and words, and I told each of you that I was being very careful not to disclose any facts that I might know that you might not know in the event that you would sit as a panel to make a decision on any action to be taken as a result of this investigation. Mr. Traub has indicated to me that he will recuse himself from any such deliberations. Mr. Cavagnero was the only interviewee to have counsel during the interview, but during each of the interviews, as I said, I had several statements, and I asked each of you to keep the conversation confidential. I did encourage candor by saying that what I would not do is attribute particular comments to individuals to the extent possible. As I said, this investigation arises from the events that occurred at this September 11 meeting, but in the course of it, I asked each of you if you were aware of any similar conduct at other meetings. I have been very conscious about not expanding the scope of this investigation. And that means that I have not investigated other topics or issues that may exist at the Board of Education. And by way of example, I have received documents, and I'll tell you about those in a moment, but I have received and reviewed documents and spoken to each of you as board members, and I've asked, for example, about how that school improvement committee meeting was scheduled, who was required to attend. But what I've not investigated, and I don't address in this report, whether there are any issues about the underlying, for example, legitimacy or legal basis of that meeting. I give that as an example because I have spoken to at least one of you about that, and I did not understand and don't understand my charge to go beyond the scope of that meeting and any similar conduct as was alleged. The fact is that meeting occurred, and I have investigated the conduct at the meeting. At the conclusion of each interview, I ask each interviewee to identify any other topics, witnesses, or documents that I should investigate. And in the course of that, I have reviewed relevant board policies, board documents, your bylaws, a document called Code of Ethics, agendas, minutes, videos, contracts, and other relevant materials. That's my process and by way of introduction, and now I will just move to my findings of the investigation. On September 6, 2013, Superintendent Kloxko sent an email to Mr. Cavagnero, who was the chair of the School Improvement Committee. The superintendent asked whether there would be a meeting on September 11. If not, she offered to cancel the meeting, which had been done for the previous 2 meetings. That means in August and July. The superintendent asked Mr. Cavagnero to provide an agenda. On Monday, September 9, Mr. Cavagnero sent a draft agenda copying the full board. That agenda included 2 items. 1, review and possible recommendations for modification of the Torrington School District Athletic Handbook, and 2, review and possible recommendations for the creation of a specific whistleblower policy for the district. Mr. Cavagnero's email makes specific requests for the administration to bring certain documents to the meeting as well. Later that afternoon, late in the day, around 5 o'clock, the superintendent sent an email response to Mr. Cavagnero stating that his first item, the athletic handbook, could not be discussed because it was being reviewed by the board's legal counsel as a result of a challenge to the handbook received from the ACLU. On the whistleblower policy, the superintendent explained that, in addition to state law, there were other procedures in place with the unions to address such concerns. Mr. Cavagnero did not respond to that email. On Tuesday, September 10, the superintendent posted an agenda that did not include the athletic handbook topic and added a discussion of board goals. It did include the whistleblower topic. The superintendent did this in order to comply with the posting requirements, and that agenda was sent to all board members, including Mr. Cavagnero, at your torrington.org email addresses. Mr. Cavagnero did not see the superintendent's posted agenda until the meeting of the evening of September 11, 2013. Mr. Cavagnaro, now let me talk about the meeting itself. Mr. Cavagnaro is a former chair of the board, and he is the current chair of this School Improvement Committee. It was Mr. Cavagnaro's idea to create the School Improvement Committee during his tenure as board chair. His tenure as chair ended in 2009. By all accounts, Mr. Cavagnaro is passionate about public education in Torrington and across the country. That certainly is my impression from talking with him. The other committee members of the School Improvement Committee are Dan Thibault and Andrew Nargi. But as I understand it, and as occurred here, board members can attend any committee meeting. At the committee meeting, the three administrators, that's Ms. Fazioli, Ms. Lumbowski, and Ms. Sosnowski, were asked by the superintendent to attend this meeting to discuss the changes in curriculum as part of the board goals discussion. The superintendent herself was not present at this meeting, and instead she attended a different meeting in the building at the same time. In the past, the assistant superintendent had attended these SIC meetings as the staff liaison, and this was the first SIC meeting since the elimination of that assistant superintendent position and the creation of the CIAT positions. None of the three administrators who were present had attended committee meetings previously. Ms. Lumbowski was the only one of the three who had worked in the central office previously, but she had not attended board committee meetings. Ms. Fazioli had been the assistant principal of the Torrington Middle School, and Ms. Sosnowski had just joined the district as a new employee in the beginning of August. The SIC meeting is scheduled to begin following the completion of an earlier committee meeting. And frankly, there are differing accounts of when the meeting began, and I'll talk about that in a moment. The three administrators arrived before 7 o'clock because they believed it started at 7. Mr. Cavagnaro arrived sometime after 7, but left the meeting room for a short time. Mr. Nargi arrived as Mr. Cavagnaro was returning. The group waited for the other committee meeting to finish so that board members Dan Thibault and Ellen Hone could join, which they did a few minutes after the meeting started. Before Mr. Thibault and Ms. Hone arrived, Mr. Cavagnaro saw a copy of the agenda that the superintendent had sent out. He reacted very strongly and immediately and became angry and loud. He said words to the effect, "This is crap." And he said he would not follow the agenda. He said it was his meeting and it was his agenda. Mr. Cavagnaro was upset that the agenda he had requested and had sent to the superintendent had been changed. He was pacing in front of the door, leaning over the table, shuffling papers, acting in an aggressive manner, pounding the table, and pointing his finger at the administrators, and they perceived those actions to be directed at them. He used mild profanity. The administrators were intimidated and taken aback. It was their first meeting. They described Mr. Cavagnaro, and they used words like yelling, and said that he was rude and unprofessional throughout the meeting. The board members who were present described Mr. Cavagnaro's voice as raised, but said he calmed down as the meeting progressed. The administrators used words such as bullying, harassing, threatening, and intimidating to describe the conduct. But all present, administrators and board members, acknowledged that some of Mr. Cavagnaro's behavior also was directed at board members, including such things as being dismissive, raising his hand in front of them, talking over them, and cutting them off. The meeting continued, and the group did, in fact, talk about the athletic handbook and the whistleblower policy issues. And during the meeting, Mr. Cavagnaro directed Ms. Lumbowski, who was taking notes, to add statements to the minutes. Most of those present, not all, but most of those present thought Ms. Lumbowski was taking minutes. At past SIC meetings, the assistant superintendent had taken minutes, and my understanding is that this is the usual practice for staff liaisons at other committee meetings. There was substantial discussion. Following the discussion, the meeting adjourned after a motion by Dan Thibault. Noteworthy is the discussion of the minutes. As I said just a minute ago, Ms. Lumbowski kept notes and she prepared minutes. She gave those minutes to Mr. Campolita during the week of September 16. I understand that those minutes have been posted publicly, although past the FOIA deadline. On February 27, Mr. Cavagnaro submitted a separate set of minutes to the superintendent's office and sent them via email to all board members. This was the first time he had prepared minutes of these meetings during his tenure as SIC chair. The minutes vary on the description of the discussion and on the basic details of the meeting, such as the start and adjournment times. I understand that both of those minutes have been made public. Let me talk about my observations of Mr. Cavaniero's conduct at the SIC meeting. In evaluating these allegations, I think it's first and foremost important to note that there is no evidence that Mr. Cavaniero committed any illegal or criminal acts, made physical threats, sexual harassment, or abusive behavior. He also, in my view, did not make any defamatory statements about particular individuals. But I will say that his words and actions at that meeting were inappropriate, unprofessional, and insensitive. The threatening behavior that was perceived by the administrators was not physical. But based on comments that Mr. Cavaniero made at the meeting about the reorganization and the administrators' new positions as CIATs, they perceived their positions to be threatened or in jeopardy. That's what they mean when they say threatened. That's how I understand it. Such comments, especially to employees new in their jobs, were inappropriate but not threatening. That's my view. His actions were seen as intimidating, which led to allegations of bullying, and I analyze that in a minute. Although Mr. Cavaniero himself acknowledges that his words and actions were blunt and that he was loud, he did not intentionally direct his actions at these three administrators. And in my view, the proof of that is that there was similar conduct towards fellow board members. Yet these administrators, in my view, there's no question, perceived his conduct to be directed at them, and they were offended by it. The board members, however, that I spoke to did not regard Mr. Cavaniero's behavior as extreme or out of line. They said, as other board members said, that they have observed similar conduct previously, including Mr. Cavaniero raising his voice and pounding the table. As I said at the beginning, and I share this observation, Mr. Cavaniero is consistently described as passionate, committed to improving public education in Torrington, and frankly frustrated about the slow pace of progress in the system. Yet the board members, their perception and apparent acceptance and acquiescence in his blunt and sometimes unprofessional and inappropriate behavior is troubling, and in my view ought to be addressed. This point is confirmed by the fact that some board members have said to me that they understood how Mr. Cavaniero's conduct could have been perceived by those administrators. Now, as I said at the beginning, with the scope of this, I focused this, as I thought my charge was, on this meeting. However, I did ask each of the interviewees, including each of you as board members, whether you had observed similar conduct by Mr. Cavaniero at other board meetings. As I've said, several of you did respond by saying you have seen Mr. Cavaniero raise his voice and take passionate positions. There were only a few specific examples when he has been perceived to, as what I'll call, go over the line. And those examples centered on public criticism and evaluative comments about the superintendent. However, other board members, I will tell you, and my observation, and I've watched some of the videos, I think it's fair to say that other board members have perhaps engaged in similar conduct. It'd be a fair thing to say that at some of your meetings, voices do get raised. And I've seen it, and you know that that occurs. And you as a board seem to share a sense of tolerance about that. And an acceptance, and in one way or another, several of you said to me, democracy can be messy. And so that is something that you tolerate. But I think what this situation talks about and points out to you is that there is a certain tolerance on this board, but it should not go as far as tolerating inappropriate and disrespectful conduct. If I go next to legal analysis, I took my charge to be asked to analyze the facts as I've just given them to you against any appropriate legal standards and relevant board policies. And I would say that I credit the entire board for beginning this investigation promptly. And frankly, it appears to me using the procedures that you have in place otherwise, for example, in the sexual harassment policy that talks about doing an investigation. This was not sexual harassment, and I want to be clear about that, but the idea of investigating something promptly, doing it independently, quickly, jumping right on it, I credit the board and all of you for that. But this situation, as I say, doesn't involve sexual harassment, and there does not appear to be a policy that directly addresses situations when there are allegations about a board member and about more generalized harassment. And as I've said, the allegations here are not physical or sexual. You do have, however, a code of ethics that governs your board. And I quote for you in my report here, there are two parts. There are several parts of that, and I'm sure that you all see this, but items number 5 and number 9 are worth pointing out. Number 5 says board members and the superintendent will always carry out their respective roles with the highest levels of professionalism, honesty, and integrity. And number 9 says board members and the superintendent recognize that they serve as part of an educational team with mutual respect, trust, civility, and regard for each other's respective roles and responsibilities. My view is that Mr. Cavaniero's conduct at this SIC meeting on September 11th was not in keeping with that code. I want to address, because the term has been used, the allegations of bullying. I have reviewed the district's bullying behavior in the schools policy. This policy does not, in my view, apply to this situation because it protects students from other students and only applies to situations when there is a pattern of activity. It does provide some useful analogies, and I commend them to you, particularly the definition of bullying, which includes overt acts with the, quote, intent to ridicule, harass, humiliate, or intimidate the other student. Those terms are further defined in the policy to note that in evaluating whether conduct is bullying, attention should be paid to the words chosen or actions taken, and whether such conduct occurred in front of others or was communicated to others. So again, I would say my perspective, and I will tell you that asking that question to most of you, I think the common thread from talking to you and looking at the overall situation is I do not believe that Mr. Cavaniero engaged in what I'd call bullying activity. He did not intend to harass or intimidate any specific person, but as I've said, his conduct at the SIC meeting was perceived as such. I do commend that policy to you as a useful guide for appropriate behavior for each of you as board members. I would conclude by saying, based on this facts and legal analysis, I do have some recommendations. I would tell you and commend you for taking this matter seriously, taking appropriate action quickly, investigating this. I do believe some action is necessary, and I recommend it. However, it is not my role as the investigator or to do this analysis, and I defer to you as board members and your counsel on the proper procedure and remedies. I do recommend the following things that you consider. Number 1, that there be some action taken with Mr. Cavaniero to recognize that his conduct at the SIC meeting was inappropriate. I would consider having him apologize and clarify that his conduct was not directed personally at the administrators. Number 2, I suggest some training in communication styles and skills for Mr. Cavaniero, particularly I think in this circumstance, he did not perceive how he was taken in that meeting. Frankly, I recommend that there may be some training for all of the board members and you do something as a group on communication styles and techniques. What follows from that is I recommend that you look at the relationship between the superintendent and the board. That is the point of the connection, and although I have seen it in other boards I've worked with, I think that it would be wise for you to have open communication and discuss about what are appropriate interactions with the board and the staff and the superintendents. The next, I would recommend that there be implementation of formal guidelines governing behavior at your board and committee meetings, including such topics as use of time, respect, courtesy, agenda setting, minute responsibilities, Robert's rules, and other policies, such as awareness on what bullying is. And this, I know some districts have this. You may consider adopting a board handbook and having appropriate accompanying training. Finally, I would ensure and stress strongly that there should be no retaliation in any form against the administrators who have raised this complaint. Those are my suggestions. It certainly is not an all-inclusive list that you may come up with, but those are my thoughts, my conclusions and recommendations and legal analysis. I thank you for the opportunity to do this investigation and am happy to answer questions as you would like.
Hang on 1 second here. The board has to take this investigation and decide if the board feels that a hearing is warranted or if enough information has been given that the investigation would be closed. Now, that would be the action item that is on our agenda. We have to be very mindful of the questions we ask Mr. Stoller, because if there is going to be a hearing, we cannot discuss the testimony or allegations in specific, because that would be the information presented at a hearing. And if we were to discuss it now, that would destroy that. So, Mr. Kisco had his hand up first, unless he wishes to defer.
Mr. Stoller, you have recommendations, but I look at the motion passed by the board, which doesn't say anything about recommendations. Why did you include recommendations? Were you asked to do that by anyone?
No, I was not. I was asked to do a legal analysis, and I thought putting this together, I thought it appropriate to provide those types of recommendations. And Mr. Kisco, I will tell you that I reviewed those recommendations with my contact, Mr. Trout. But no, I did not. I wasn't specifically asked to put anything in there. And you see that on top of that paragraph, I'm also very careful to say that I certainly defer to the board and its counsel on the proper procedures and how you proceed. But these are recommendations. Frankly, I thought it useful, based on all of this, to make recommendations. And you'll note that some of them are directed towards Mr. Cavagnero, but some of them, in fact, the majority of them are directed more towards the board as a whole.
But none of them were requested by the board.
That's correct.
Thank you.
I'd just like to say I'm happy that the board did this investigation internally. I'd like to actually make a motion to accept the recommendations, removing item number 2, but following all of the other recommendations.
So your motion would be
Accept the
to
recommendation.
close the investigation with the outcome of essentially an apology, training for board members for communications and styles. I'm reading your page, but I have my own short. And
Removing item number
Yes.
2, specifically individual training for Mr. Cavagnero, but including
just as a board.
as a full board and not anyone individually, and not having a hearing and closing the investigation. So,
We had the second. Chris. Discussion about accepting that, Mr. Cavagnero?
Do I get to say anything at this hearing?
As far as,
Well,
this isn't a hearing, first of all. If the board votes that there is a need for a hearing or a disciplinary action against you, then there would be a hearing.
in the name of due process,
Okay.
this is a public meeting. The reporters, cameramen, the public is going to hear what has just been said about me. Do I have the right to say this? Do I have the right to in some way defend myself? These words, his conduct was aggressive, harassing, intimidating, and abusive. I would like to know, how was I abusive?
Well,
I would like to know
before-
why the 3
Paul.
people who accused me are not even here to answer that.
Because it's not a hearing and there isn't that give and take in this. This was just to receive the report.
It's not a give and take, but it goes into the public record. Surely there's a point at which, after 10 years on the Board of Education, volunteer work trying to move this district forward, following in the footsteps of my father, who spent 12 years on the Board of Education as a volunteer, somewhere, in addition to serving on many other boards in this town, all free, all without making a dime, somewhere, someone has to say, I don't, this is very close to being defamatory against my family name, quite frankly. And at some point, I should have the opportunity to address this. The people who are accusing me of making all these comments are not even here. They're claiming, they're using very strong, like pound the table. I remember pointing, I do this, is that pounding? Is that really offensive to people?
Paul,
You know?
and again, I don't want to, they're not here because it's not a hearing. This is not to put you on trial. This was to get the results of an investigation and to decide if a hearing is warranted or if it doesn't rise to the extent of being misconduct and there is no hearing.
As long as the reporters and the press record that I take great offense in not being able to have a discussion and be able to address the language that's used in this report and ask some serious questions about the people who are using this language against me. I don't think this fairly represents me. I don't think, this is how I conducted myself at the School Improvement Committee meeting. Is this truly offensive to people? Is this truly out of line with being a good board member? Is this truly out of line with trying to make progress on bullying, okay? And on a whistleblower policy, because we've got tons of problems within this district, and it is, yeah, extraordinarily frustrating to attend a meeting that, as chairman, I set up and am prepared to discuss and find out that there's a separate agenda that is not of my doing, that I never approved of, and et cetera, et cetera. There's far more to this.
And I understand. And it's whether the board wants to have a hearing to discuss it or whether the board does not feel that your actions warrant a hearing. That there is no, that there is no merit to the allegation, that people may have felt that you were, I have to get the right word, loud and passionate, or whether you were abusive and...
They said they were threatening their jobs?
Well,
I'm a school improvement committee chairman. How in any way, shape, or form in this highly structured public education environment could I possibly, there is absolutely no mechanism for me to have any impact whatsoever on their employment, whatsoever. And if I cannot have any impact whatsoever on their employment, how could they possibly feel threatened? So therefore, it goes to the very heart of, what does any of this mean? Really, what does any of this mean? You know?
Mr. Chairman, the motion itself may be out of order because I don't think it fits the agenda. And instead of receiving this report, it's jumping ahead and acting on the basis of recommendations nobody asked for.
This is under possible action of investigation.
So this is a possible action. Before we're done asking questions.
Okay.
Well, we're still on number 3, aren't we?
Yes.
Receipt and discussion of.
We will table the motion and we will go back to the discussion of the original.
We vote on tabling it, don't we, Mr.?
Not unless he rules the motion out of order.
We'll rule the motion out of order and it will continue our discussion until we get to agenda item number 4. Our resident Robert's rules.
I'm curious, did Mr. Cavanero acquire his own independent counsel during the hearing?
Yes.
I can explain. Because at the point at which I was asked to meet with Mr. Stoller, at that point, then up until that point, I literally had no idea what the specific charges were. I did not know who was bringing them. I did not know what my rights were. I had no counsel whatsoever, and I was being asked to talk to an investigator. I would just ask every single board member, whatever action you take tonight, I've said this before in many other contexts, whatever you do today becomes past practice for tomorrow. You set a precedent, okay? And whatever is or can be or should be done to me, I would just ask you to take a step back and say, what would this be like if I were in his shoes? What would this be like if a future Board of Education member were in his shoes 2 years from now? That's all. Thank you.
That was a good closing argument. That was a good closing argument.
I just want to make sure this wasn't on the school's dime. I just wanted to, that was my concern with that. That was really my only concern, that it wasn't more money from the district to have to pay for this.
Well, to answer that question, as long as Mr. Cavanero's conduct is not considered willful or intentionally negligent, then it is on our dime. All board members are covered.
I was referring to his independent counsel.
That's what I'm addressing.
Oh, we would have to pick up
Yes.
that tab?
Unless there is a willful misconduct on his part, which the report says there was not. It alludes to the fact that there was not a willful misconduct.
What is our counsel?
Mr. Traub is correct that under the statute in Connecticut, Section 10-235 of the Connecticut General Statutes, board members and all employees of the school district are covered by the same statute, and as long as they act in the scope of their responsibilities in the course of their duties, and they don't act in a wanton, reckless, or malicious manner, those are the three words of the statute, that the board is obligated to indemnify and protect board members and employees of the board in connection with claims of various sorts that are brought against them that are pending in some way.
And to defend the fact that we used an outside investigator so as to not make Shipman and Goodwin unavailable to us for counsel. Mr. Cavanero had to do the same. He had to seek outside of Shipman and Goodwin so that Shipman could be the board's attorney, and then he'll get reimbursed for his legal cost in the situation.
Regardless of whatever action is taken, whether.
Unless it is wanton.
Ultimately, the statute protects board members as long as they're, any board member, if they're acting within the scope of their responsibilities and duties, and they are not acting in a wanton, reckless, or malicious manner.
So as soon as we accept this report, we are responsible for Paul's legal expenses?
There's a separate, that's actually a separate question in terms of, I mean, and that's not on the agenda for this evening at all. From my perspective, there's a separate question, but I believe Mr. Traub has indicated, and I have indicated the basics of the statute and how that works. That would be a matter to be addressed separately beyond tonight.
Full support of paying
Can
Mr.
I just
Cavanero
continue
legal
around? I'll get
expenses
right back to you.
for anyone else that was on the board, defending themselves.
Did you have any other questions?
That was it, thanks.
Chris, did you have any questions? No. Andrew?
Yeah, I have, I raised these issues with the attorney when I was interviewed, and what really amazes me is in his report, he states there is no written complaint. So you're saying even as of this date, you still have not received a written complaint?
I think as I explained to you, Mr. Nargi, when we met, there were two documents that I had, and I don't regard either of them as written complaints. There was an oral report made by Ms. Limbowski, which she then wrote up minutes, and so, which I know have been disclosed, and that was not in the form of a complaint, a written complaint, one. And two, as I say in this report, Ms. Fazioli spoke to the superintendent. The superintendent did keep some handwritten notes. But again, it's not a written complaint. That's the record, that's the document. I have not received any kind of written complaint, and if there is one, I have not been able to uncover it.
And I raised this issue with you as well, which was, are these people, the complainants in this action, are they acting within the context of being administrators, which would entail a whole process in which a grievance process would be initiated, and to start that to do that process of filing a complaint that they were harmed in some manner, it requires that a written complaint be filed with the superintendent. And again, being that this is, to me, is so convoluted as to their relation, these three women, and I assume they're the complainants, their relationship to us as board members, I don't really understand that relationship. I don't see how they were even able to have the standing to file. First of all, they didn't file any documentation.
They made oral complaints.
Oral complaints, and like I said, if they're part of the administrator's contract, it clearly states what has to transpire for them to file a complaint. And one of the things is, if it goes beyond the level of the superintendent, it's supposed to be in writing. And that's done so as to give notice to who they're complaining about, what behavior they're actually complaining about, so that that person has some type of procedural due process, and in this case, even substantive due process. That's the first problem I have with what's transpiring here. The
Do you want
second,
an answer to it, or do you just want to keep going?
yeah, who's going to address this?
I'm happy to answer that question because you did raise that question with me. I took that very seriously. You gave me the administrator's contract. I read the administrator's contract. I considered that. And I think one of the things where I come out on that is what you just said there, is that this is kind of a situation, this complaint was made against a board member. If you read the administrator contract, there's nothing in there about a board member actions, number one. Number two, I'm not sure that it would therefore then be recognized as a grievance under that contract. And you know, I started also my report by saying I do compliment the board from addressing this. I mean, this complaint was made, there had to be a decision on what to do. There were oral complaints, what do we do against a board member? And the decision was we should do an investigation and get to the bottom of this. It doesn't, in my view, it didn't fit in that block on the administrator contract, and that's why I didn't consider that. Although I want you to know that I took that very seriously. I went back and looked at that. And you're right, if a grievance goes to one of the higher level steps in the administrator contract, as is true in most collective bargaining agreements, yes, something has to be written down. But in this case, you know, I'm asked to investigate. Frankly, I met with each of the women. I understood the circumstance. I understood what their complaint was. And so I didn't regard this as something to come back to you and say, well, we shouldn't do any further investigation because there wasn't a written piece of paper.
Then what is their legal relationship to Mr. Cavanero or to any board member that would be able to allow them to precipitate and start this whole process to begin with?
Here's my analysis on that, Mr. Narji. Having done lots of investigations, including harassment type investigations, what I looked at that is yes, they did not report to a board member, and so this is different than, you know, if this allegation had been made against the superintendent or against their direct supervisor. However, my view, and certainly in Connecticut and certainly under federal law, when there are harassment type investigations, it is very clear that you don't have to have that employer-employee relationship. If, for example, there was a board meeting and for some reason one of the committee members or you invited to this board meeting an outsider, let's say a consultant doing something or another, and that person was inappropriate, did something that was unprofessional, disrespectful, abusive, you can fill in the blank. In that case, it may be appropriate to do an investigation even though you don't have that relationship. So I looked at that. I considered seriously what you said about that, about meaning that these administrators didn't necessarily report to the board member. But I believed, after hearing the allegations, hearing the complaint, knowing that that similar complaints had been made to other administrators orally, that it was appropriate to go forward and do this investigation, and you see my results.
Well, the second issue, and I raised that with you as well, which was it's the superintendent's contract. And on page 2 of the superintendent's contract, it states that the superintendent shall attend all meetings of the Board of Education and shall participate in all board deliberations except when matters relating to her own employment are under consideration. The superintendent or her designee, as authorized by the board, shall attend all board committee meetings. When did the superintendent ever get the permission from the board to authorize them to sit in her place that night?
Again, Mr. Narji, I did review the superintendent's contract and that phrase that you provided. I looked at that, and in fact, when I addressed that in my report, I have gotten documents from you and others, and when I talk about the scope of the investigation, what I didn't think I was charged to investigate is who should go to that meeting or who should not go to the meeting. You may be raising a great point that that contract says that. However, what I didn't do, because I didn't think I should expand the scope of my investigation, is to go into all of what that means and whether that had occurred in the past, because I've also understood that up until recently, the person who attended those meetings was the assistant superintendent, not the superintendent. I mean, I've been told that by several sources. And so doing that investigation would have entailed, let's go back to see through all sorts of records to find out if there ever was that authorization. And as I went down that path, I said, wait a second, what am I supposed to be doing here? And the fact is, I was charged to investigate the conduct of Mr. Cavagnaro at that meeting. And so whether or not that meeting was scheduled properly when it started, whether there was the wrong people attending, the fact is the meeting occurred, and I've investigated the conduct of it, and I've tried to keep my remarks and my findings to the conduct there. So you raise a point. It is in the superintendent's contract. I agree with you. Frankly, I didn't think it was relevant to my findings in this report.
Or, for that matter, well, Andrew, the conduct between a board member and an employee of the district, regardless of where they are, is what was important. I mean, the superintendent was at another meeting. That doesn't mean the superintendent wasn't coming to this meeting. That doesn't mean that if it still gives grounds to abuse or be mean to somebody because they're not the superintendent. I mean, other people attend all the meetings. I mean, the director of human resource goes to policy, and the business director goes to budget. So does that mean that it's open season on them because they're not the superintendent? I don't understand your question.
No, the issue is that you have a, I don't know, maybe it's an 8-page contract.
But what does that have to do with the fact that these
Because
women were at a meeting?
There's a reason why, you're asking the question, and I'm telling you.
I didn't finish, but go ahead.
Okay, well, I mean, I'm trying to explain to you that whoever drafted this contract, who thought it was important enough that there's not a lot of things that are put in this contract that are specific about the superintendent really doing anything except boilerplate legalese. But for some reason, it was put in because they felt it was very important, and it probably stems more with the fact that this is to protect the superintendent so that she is never excluded from the board, where the board can have meetings without the superintendent being present. But that being said, I firmly believe that the reason why the superintendent should be at these meetings is because as a board, we only have a relationship ultimately with one person. We oversee only one person. We only directly communicate with one person. And for the superintendent not to be there and not to have had the board's approval of authorizing someone that the board would want to be in her place, puts board members, and clearly in this case, Mr. Cavagnaro, at risk that other people who are not accustomed, who don't understand the relationship that the board members have with the superintendent, are now, as is evident, subject to this whole investigation and potentially some type of sanction being imposed against the board member. I find it egregious that it took place. When the superintendent wasn't there and the meeting was to begin, my first thought was, I want to get up and leave. Because this is not, I've been on the board 6 years, I don't really remember ever being at a board meeting where the superintendent did not attend.
Putting that aside, I don't know if there was ever an official decision that these people were there to replace the superintendent, but it still does not give anyone the right to holler at or to be inappropriate with anyone, any member of the public or employee attending a meeting, Andrew. So we're investigating the conduct between people that were at the meeting and a member of the board. We're not debating whether the people should have been there. I mean, public come to our meetings all the time. That doesn't mean you just... that's not the topic of this conversation.
And I understand what you're saying, but what bothers me is if anyone in the general public, not an employee of the district, hears me, all of a sudden I get so upset I start using some profanity. does that person in the audience now have standing to bring forth a similar claim against any of us? And that's how I feel the relationship of these three people were to the board. They were nothing other than people from the general public. I don't view us having, as board members, any type of legal relationship to them than that of
As
the general
employees
public.
of the Torrington Public
No,
School System.
we have nothing to do with their employment. We can't
They are-
supervise them, we can't evaluate
They're
them.
employees of the Torrington Public School
Right.
System. You are a board member of the Torrington Public
Yes.
School System. You cannot just berate or belittle or attack someone who is an employee
No, not our
of the
employee.
district that you,
No, I have no, it's.
you're the governing body of the Torrington
Yeah,
Board
but
of
I have
Education.
no ability to evaluate, to oversee anything of these people, and they know it.
But you
I mean,
still-
not that, I'm not saying them
Okay,
specifically,
that-
but as
that's-
a group, they
That's
know
outside the
that.
scope of this investigation.
It's
so-
not, though.
It is, but we're gonna move on to Mr. Thibault. We're gonna finish going around the table, and I gotta get this together. Nothing? Mr. Kevin? Took a while to get to.
I think where Mr. Nardi was going with this was a big part, since he was at the meeting, was a big part of my frustration at the beginning of the meeting was, I would just ask my board members to try to clear their minds from what was said, and just think about this. My frustration was, when I showed up at that meeting, being handed the agenda item that I wanted to, the whistleblower, because as you read, there was specific information that was given to me over the summer about the school administrators who were requesting teachers. The word that was used actually by the person who reported this to me, bullying a teacher in one case, to change the curve to, so that, to create the effect that more kids, more seniors would be passing than otherwise would have happened. Which of course is very disturbing information. So I want to discuss a whistleblower policy to provide a mechanism whereby this type of information come forward. The other one was clearly something I've been discussing since March. The board itself had heard this. The board itself had directed me to discuss this at the school improvement committee meeting, which was the agenda item about automatic suspension of any school activity for any student arrested on a felony charge, okay? Now, at the public meeting prior to my school improvement committee meeting, this board, you in particular, Mr. Traub, asked to elevate that from the student athletic handbook to a more general discussion of the student handbook to be more encompassing, which I totally supported and agreed with, which is where I was going at that meeting, okay? So then I walk into the meeting, given a different agenda than what I have by 3 CIATs, and I did have a conversation. I said, why are you here? Why are you can't represent, my feeling was you can't represent the administration on these issues because you don't have district-wide responsibilities. You, theoretically, according to the last org chart, you report to principals. So how can you discuss policies? I mean, it's not, you know, this is not appropriate. We can't get things done in this regard because it's not fair to put you guys in positions to speak on behalf of the entire administration. And that's when they said there was a different meeting, and that was the subject. This regarding, was I frustrated? Yeah, regarding the emails on my iPad, and I described to them that everybody who tried to get in touch with me about things that were important got on the phone or sent emails to my work address, that I simply have 4, in addition to my Torrington Board of Education iPad. I've got 4 mobile devices I'm responsible to carry around. 3 are work related, 1's personal for my 2 kids. And that's just an awful lot to carry around, and I just can't be doing that. And I've asked consideration to send, I'm always on my work email and to send information there. The minutes I sent, as everybody will know, came through, once again, from my work email, because I'm always on my work email. So, yes, am I culpable? Did I not read this? Yes, I did not read that. I never do. How many board members here get phone calls when they have meetings to be changed? Does everybody communicate here? Never phone calls? No? No? Did I ask for that exception? I mean, Mr. Traub, you did. You call me, send me little text messages when you need to send important information, because you know you'll get me there. Yeah. I consider the Board of Education and its subcommittees, I consider the chairman of a subcommittee to be able to set his or her own agenda and discuss the matters that important. That's what I think I was elected to do. And by representing the public, my feeling is I represent the sentiments of the public. And when we see, and so that particular item, both of those items are very, very important to me. I've been trying to discuss them for a long time, since March, with the automatic suspension policy, given the fact that there was so much press made about student athletes and rape. I thought that the Board of Education had to move decisively in some direction to send the message to our community that we were aware and that we had a process in place for dealing with, not for dealing because you can't solve it, I get that, but that we are very much aware and we're trying our best to in some way influence and control that behavior. Very important to me. So when I walk in and I'm told I can't discuss this by 3 CIATs who at that point in time can't even tell me who actually posted the new agenda that wasn't mine, yes, I was frustrated. And then to be told that I can't discuss that expulsion because this student handbook, the athletic handbook is being embargoed because we are being, there's a ACLU litigation against us, was even more frustrating because the language that the ACLU was objecting to was language, Mr. Mills, I do believe that at least 9 months prior, during policy committee meetings about the use of mobile devices, phones, and social networking within our schools, your law firm advised us very clearly that that was a political landmine to avoid in any kind of policy. That First Amendment rights, that it was very gray, that you couldn't just, that you couldn't simply ban students from doing that kind of stuff. I remember hearing that our legal counsel, Chip and Goldman, had told us to avoid that until there were other cases, and that it was just to avoid that. And so the policy, the athletic, initially my request for the athletic handbook to include language about automatic suspension is now in a sense contaminated by language that we were advised by counsel months and months and months ago to avoid. So I can't talk about what I want because of a decision to include language that we were advised, that the board was advised, the administration was advised not to include. On top of which, the whole point of that agenda item was to move the discussion off of the athletic handbook onto the student handbook to broaden it and expand it. So yeah, it was frustrating. Yes, it was. So I just like to paint that as the context within which this meeting transpired, okay? No one could tell me who posted this. Somebody, actually one of CIT said they thought you, Ms. Paluccio, actually was the one who came up with this. I don't remember who said that, but they said, yeah, they said they think Ms. Paluccio came up with this. That didn't sit too well, okay?
Well, to be technical, she does post all of the agendas.
I said, who came up with this? Who modified it? And they said, well, I think Ms. Paluccio did. I said, okay, so within that context, the meeting got off to a bad start, let's just say that. What I would like to, so I think in some respects what Mr. Nargi is alluding to is how the meeting progressed in terms of evaluating how I did and what I said and how I did it, handle myself. An awful lot of language going to that these 3 CIATs felt abusive and that I was somehow singling them out and they felt threatened. The 3 board members who were there, will you please answer this? What I don't find in Ms. Lebomski's minutes at all was a singularly glaring omission. Do you not remember me stopping at one point and saying, these comments are not directed toward any of you 3? That I don't know you 2. I pointed to Ms. Sosnowski and Ms. Gazzola and said, you 2, I know, I recognize you, but I've never actually met you, but I assume that since you have these jobs, you are very competent and qualified to have them. You, Ms. Lebomski, I know as a principal of Forbes, and I know you to be very, very good at what you do, and I have a lot of respect for you as a principal of Forbes. And so these comments about the administration are not directed toward you, and they're not even directed toward the superintendent. I said, I've been through seven administrations in my 10 years on the Board of Education, and I have a lot of, I can call back on a lot of examples to support my comments. Do you guys not remember me saying that? Because I stopped it and directly addressed it. You really don't remember that?
Well,
I find that hard to believe.
it's not a hearing.